Mwangi. I'm an advocate of the High Court of Kenya. And with me, I have Mr. Muteithia Kenson, also known as Small Daktari. Daktari is a student at the Kenya School of Law. Kenson, proof of life, just say hi to the audience.
Kenson, Muteithia, as introduced, I'd like to say hi and hello to the audience of the legal tumble. It
Thank you so
reminded me when you say Daktari with a small d, dr, I remembered about the president of of the Law Society and the president of Uganda. When the president of Uganda saying that I am the president with a capital P, all the other president are small p's.
What does that mean?
The president of Uganda was
Yes,
invited. I think it was an organization of it was an event that had lawyers of
ah,
the society.
okay,
So everyone was standing and they were introduced as president of the Law Society of Uganda, president of the East African Law Society. And it
okay.
was the turn of the president of Uganda. He
Mm-hmm.
was very keen to remind the audience that
Okay,
all the other P's in the room were
okay.
president with a small p and was the only president with a big P. And
That's
that is
nice.
where now the conversation of president with small p actually started from there.
Oh, yeah, yeah. Now he's saying he's like the
Exactly.
big president. He's actually the real
Exactly.
president. So,
Yes.
yeah. Okay, yeah, Kenson. At least, so this week there's been a lot that's really happening in Kenya. And actually, the big issues that are legal in this country right now is only the finance bill. There's been a lot of noise. There's been a lot of hula baloo even before the bill was tabled. So, what do you think about the bill? If you have any thoughts, that is, you might not have any thoughts. Like maybe you could be like me. I am ambivalent, I would say. Like someone told me, maybe. So, what do you think?
Um, First of all, I think for me, the starting point is that we are almost used to this procedure in Kenya
Yeah,
because the finance bill is introduced every year
yeah,
at around this period. I
yeah,
think the first reading of the finance bill was somewhere between 13th May
oh
2024.
yeah,
That's when it was presented for the first reading, and I think it was then put to the committee, finance committee, to gather public views, public participate, to facilitate for public participation, to gather the views of the people in terms of the bill itself and
yes, yeah,
what have you.
yes,
Now, the bill as it is, of course, it seeks to introduce or to have an additional 300 billion shillings. Now,
yes,
that's quite some amount to
yeah,
given the financial situation and the economic situation of the country and the world at large. And of course,
yes,
the projected revenue is 3.3 trillion.
yeah,
Previously, we have seen, of course, the KRA, the Kenya Revenue Authorities, meeting some certain threshold in terms of meeting the collection linear and what have you.
target,
But one of the most obvious things was that there was some very what has been described as some insensitive or punitive taxes.
yes,
And true to that word, when the bill was being presented yesterday, and which is going to be debated yesterday, today, and
mm,
tomorrow to have the vote,
mm,
the
yes,
committee decided to drop some of these things. One of the most notorious taxes was, of course, the motor vehicle, uh,
yes. Motor
levy that
vehicle
was.
levy. You see the motor vehicle levy that is like what is it? Should it, we are borrowing from countries like Singapore, which we aspire to be.
Yes.
That's what we are saying. Yes.
Exactly. But the difficult part for me, I think, was because once you introduce the motor, we do still have the road development levy and a whole
Yes.
a whole lot of other levies that are around this aspect of petroleum and road
Yes. Road
uses and what
usage.
have you. And
Yes.
of course, there was some ambiguity in terms of how this amount is going to be brought in terms of the cap being that 100,000 shillings cap and the
Yes.
amount that was. There was some sort of ambiguity and what have you, but eventually that was dropped, at least in
Yes.
the bill that has been presented yesterday.
Yeah.
There was also the aspect of the 16% VAT introduced on
VAT.
bread, which was
Yes.
of course attracting a lot of attention.
Yes,
Um,
but just to cut you short, sorry, I would say
yes,
it's a curious thing. Like this tax on bread always is always there. Like I think for the last time I've been for the maybe a few years I've been tracking this bill. There's always
yes,
that clause on the bread that is always introduced. Like, it's always there,
mm.
and it always causes this clamor. And I don't know. Maybe I don't know why it's usually put there because it's already known that the people will be revolting
Will
against that
always
cause.
reject that.
Yes.
Which
So.
actually has raised an issue. Sometimes I think one of the
Mm,
most preliminary views I had was that
mm,
sometimes the government puts some of the obviously notorious taxes
mm,
so that when you are going to raise havoc and you're going to rise up a blaze about the taxes
mm.
that are being introduced, of course, when you see a
Yes.
16% VAT on bread, you're not going to look at
Yes.
any other thing
Of course.
and you're
It's
going
what
to
is called
focus on
I.
that.
Yes.
And once they want to, of course, save the day, they are going to drop it. And then they're going to tell you, we listened to you.
Oh, yeah. It's what is called the political craft and legislative craft. Yeah.
Exactly. It's just hubris, it's just political calculations. Because I think I
Yes.
was
Yes.
having a conversation with one of my friends today, and I was telling them that politicians take calculated risks.
Yes.
There is nothing as a coincidence that you would shock them. At least one of the, of course, the obvious things that might have shocked the government this time is about the middle class and the Gen Z's attitude towards this bill because it has not happened before. Before you have
Yes.
seen opposition against the finance bill from recognized opposition leaders, but this time you can see that there is no actually opposition leader who is calling for the demonstrations. It is coming from the grassroots level and what have you. This was something at least that was not anticipated. But one of the
Okay.
things that for sure they had anticipated is that the bill was going to be opposed to a certain extent, and they knew they are going to bring down some and remove some proposed uh, taxes
Yes. Yes. I would.
because they put out, of course, an exaggerated budget, knowing very well they have an calculated budget that they want to pass, and they will eventually pass it. In as much as there is so much noise that is being put across, and what have you. But
Yes.
if you
Yes.
were to look at from the legal perspective in terms of the
Yeah.
bill and
Just to cut you short before you proceed on the legal perspective, because
yes,
it's also, as you said, it's surprising that there is all this clamor or this debate on this bill or this bill that is a finance bill. Because as you look at the finance bill is actually a very, very complex piece of legislation, which really
absolutely.
is actually surprising that people now are really starting to engage with legislation because it's really not, it's something that really unprecedented largely in Kenya, where you see people really starting to take their time to start to try to understand. It's not, does not mean that they do understand, but just a beginning, like a beginning of a cascade of interest in legislation, the legislative process itself. So as even as you discuss, if you give your thoughts on the legal on the finance bill, it's also good for us to reflect on how the people now are starting to engage and why we should also try
Mm,
to improve in our legislative drafting and also try
absolutely.
to provide to increase the public visibility of acts and bills of parliament.
Mm,
Because-
mm,
Yes.
mm. For sure. I think one of the very commendable aspect is how people want now to engage the issues in terms of
Yes.
the finance bill itself. As you've mentioned, it is a very technical bill. I think it is one of the most technical bills that actually is ever introduced in Parliament. First, of course, because it
Mm,
is a bill and a law that is meant not only it is not a
mm.
standalone piece of legislation because what it
Yes, it's
does
not a
is
standalone.
it amends different pieces of
Mm,
legislations across,
exactly.
and not so many people appreciate what this means as
Yes.
being a miscellaneous statute.
It's like a miscellaneous amendment statute bill or something like that.
Absolutely, absolutely. Which makes it a
Mm,
little bit complex, knowing that
yes.
they have brought these and what have you. But the fact that Kenyans are actually asking very pertinent questions regarding this, I
Mm,
think, is a very good starting point.
yeah.
Of course, I know sometimes in 2022 they introduced the draft national tax policy,
Yes.
which is aimed at just curbing this unpredictability. Of course, it's not sustainable to always
Yeah.
have a new finance act every other year. And if you want to see the how unpredictable and unsustainable that is, the
Mm.
Finance Act 2023 is still in court.
Oh, yes. There's still
Uh,
pending
the Court of
pending
Appeal is
litigation.
the Court of Appeal is still considering. Not worst bit is that even the conservatory orders application is still in court.
Wow, still pending. Oh, yeah,
Eh,
and now we're
eh,
in a new cycle.
and we are in a new cycle already.
Wow.
Which can tell you how unsustainable that is.
Yeah.
Assuming we had a very outright government that was going to impose very punitive taxes, and
Yeah.
we had a very rogue court that did not want to hear, or a court that exercises an off-touch approach.
Just to pause on that
Finance
thought.
and especially,
Pause on that thought. Like, let me put a spanner in the works. Even if the
yeah,
court was really kind of robust and really proactive, I mean,
yes,
in our justice system, 1 year
yeah,
is really a short time for them to adjudicate on anything, like to
absolutely,
come to a final conclusion, especially on such a complex matter. So
exactly,
really, if the litigation starts, by the time, as
yes,
you're saying, by the time they are concluding the litigation, the
yeah.
water, like, it is water under the bridge. The whatever
It's
you
not
were
under the
litigating
bridge.
about has already been swept away.
Case in point is the housing levy.
Yes.
The housing levy was declared unconstitutional. That did not change
Mm.
anything. It
Yes.
was appealed. And one
Yes.
of the worst, of course, aspect is the NSSF. We don't have this conversation, and I think this is conversation that we should be having as a country. As it stands now, there is
Mm.
no proper at least framework within which NSSF is levied, at least after the Supreme Court remitted
Yes. Yes.
the NSSF matter back to the Court of Appeal, because the
Yes.
effect was that once in 2020 thereabouts, when the ELRC declared the NSSF Act unconstitutional,
Yes.
and the ELRC did that 10 years after the act was implemented. You can see how problematic that is. We have an
That is
act that has
problematic.
been in operation over 10 years, then
Yes.
you declare it unconstitutional in the 10th year.
Yes.
Then, even before that could sink in, the Court of Appeal set aside that decision of declaring that statute unconstitutional.
Yes.
After some time, the Court of Appeal revives the judgment declaring the NSSF unconstitutional, and you see how much of a limbo we are
Yes.
in.
Because now your contributions are left hanging. You have already been
Exactly,
trying to live according to the statute, to do whatever it says.
exactly.
So what happens to your contributions? It's the same question that people are asking now with the SHIF and then
Yes,
NHIF. Yes, there's a transitional
absolutely.
provision, but
Mm.
this is a whole new framework that we have brought in. So what
Yeah.
happens to our previous contributions? We had
Yes.
placed some reliance on this previous
Yes.
regime. So that does
Mm.
it transfer into this new regime? I had
Mm.
even some there was a press conference even by the Catholic bishops. They were asking what happens to
Mm.
all the monies, like all the pending invoices that we had
Contributions.
given to any, not even contributions. Like you see, when the
Mm.
hospitals they give the services, now they have
Oh
to go and
yes.
take to go and invoice to NHIF or to get now the reimbursement. So what happens
Exactly.
to those pending monies? So what do we do when
Mm.
we have been trying to
Mm.
live under such a reliance? So I don't know what is your what do you think? But you have put a spanner in the works, and I don't know how to
Yep.
solve it. That
Yep.
we should not be having a finance bill every year, but really we cannot
Mm.
have one finance bill like to go for 5 years or something. I don't know what's the solution to this situation, or should we just have like more efficient institutions and stuff like that? Like the court should be as efficient as parliament,
Yeah,
or what should
I
be?
mean there was a senator who was proposing something to do with to impose timelines similar to the templates that are imposed on electoral petitions, within which
Mm,
um, uh,
to
cases
determine.
challenging government policy
Mm,
should be decided. Of course, it was castigated in terms of the proposal and what have you, and
yeah.
everyone was saying that actually every other thing that goes, especially to the constitutional and judicial review division, is basically a
Yeah.
question of policy.
Yes.
And if you'll be proposing that to be the case, and then
Mm,
that will be problematic. But I think for me, it goes back to Parliament doing a good job in terms of coming up with policies that do not necessarily need to be challenged. Of course, we are
mm,
a litigious society, it is acceptable as such.
mm, mm.
But if at all we could have Parliament doing at least the basic foundations, there are some things that we have been talking about these days about patent and constitutionality. You know, we can live with latent and constitutionality, for instance, that very
Yes.
hidden aspect that would have to
Yes.
stretch our imagination. You know,
Yes.
constitutional scholars, especially, are very academic in their thinking and what have you, and they can make a constitutional issue out of anything. But if at all
Yes.
Parliament could try to deal with instances of patent unconstitutionalities, in the
Yes.
sense that you give a policy that will require the court to be really stretching its mandate to interfere with that policy. And I think
Yes.
that is where we have been failing in terms of our policies. Our policies are so easy to attack. They
Yes.
are violating certain fundamental aspect that should not be violated in the first instance. If
Yes.
we were to have good policies, then we could so comfortably entrench. And I believe in this aspect of separation of powers and having policy matters being left to the political branches and what have you. And it is only in those instances that the judiciary needs to interfere that it needs to interfere. And I like actually the approach that was used by the High Court judgment in the Finance Act 2023. You realize that they only found issue with the housing levy, and because it had some certain patent and constitutionalities in terms of the discrimination and the lack of a legal framework existing and what
Yes.
have
Yes.
you,
Yes.
but they were able to dismiss all those other issues, of course, academically speaking, which were not in aligning with the
Mm.
constitution in terms of we have not always had a very clear understanding whether the Finance Act actually is a money bill, strictly speaking, or it affects
Yes.
artists to a
Yes.
certain
Yes. Yes.
extent. But certainly, for sure, that should not be a reason, even if you were to agree for argument's sake, that it is a
Yeah,
bill that affects counties, that should not be a good reason why that the whole act should be declared unconstitutional.
unconstitutional.
And I
As you
think
say,
we
they
had
should
this
leave it to
conversation with
this.
you.
Yes, I think, as you
You
say, they
remember when
should
we were
leave it
having the
to
conversation, what is the effect of declaring unconstitutional
yeah.
such a statute? Do
What does it
you
mean? Do we go back to 2022?
exactly, or do we remain in a vacuum, or what have
Yeah,
you? And
as you said, like the Finance Act is a very, very weird kind. It's a weird kind of statute. If you say we go
exactly,
back,
exactly,
it is a statute that is amending now whatever was in 2021. So
absolutely,
it is like a domino effect, or maybe to when the statute began.
exactly,
So anyway,
exactly,
let's pause there and start try to like go marathon through whatever we were trying to do today. And I
absolutely.
think we can start from whatever you were saying. So
Mm,
we were talk about adversary opinions of the Supreme
yeah,
Court of Kenya. So
yeah.
just as a matter of just the triggering of the conversation before
Mm.
we end shortly, is could the Supreme Court give us an advisory opinion on what is the how to structure a finance bill for the next year, 2025? For example, if Parliament went there to ask for advisory opinion, could it do that?
Actually, there was an aspect of when there was an advisory opinion sold about the role of the Senate
Hmm.
in terms of devolution and what have you.
Hmm.
And one of the aspects, of course, that would lock out the question of Finance Act or what
Yeah.
should be contained or the period is because of these unique characteristics that the Supreme Court has interpreted Article 163(6) of the Constitution to mean that
Yes.
an advisory opinion must be something that affects counties.
Okay. Yes.
And we have just started by the argument that you are saying that if you look at a money bill and Article 104
Yes.
of the Constitution, it is something that is
Hmm.
just basically uh, falls under the mandate of the National Assembly.
Yes.
And it would be said that it is the National Assembly that exercises the mandate of coming up with the finance bill and eventually coming up with the Finance Act and what have you, such that they would cause that friction of saying that this is not a matter that affects counties in the strict sense.
Hmm.
Of course,
Yes.
ultimately it will affect counties in terms of raising
Raising
uh,
the revenue.
the revenue and what have you. But strictly speaking, this could be an instance. Remember, when we are having very high stake matters,
Yes.
courts usually try to be as avoidant as possible. I am
Yes.
so sure that this is something that the Supreme Court might not want to involve itself with, especially coming to say that Finance Act is a strictly policy matter issue.
Yes.
It is a matter
Okay.
that is best left to the executive and the parliamentary and the parliament branches.
On that note, isn't an advisory opinion largely a pontification of the Supreme Court on policy? For example, when it was talking of the gender issue, the
Mm.
advisory opinion, isn't it pontificating or getting into the realm of executive or legislative powers, pontificating on such issues? What is the extent? When should we do them? Stuff like such kind of pontification.
For sure, strictly speaking, an advisory opinion is meant just to give advice to the
Yes.
body requesting to be able to see how it does. And
Yes.
now, how you see that it would be unnecessary to even ask the Supreme Court such a question is because of the
Hmm.
same gender role question that the Supreme Court was asked way back in 2012.
Yeah.
And the Supreme Court actually was being asked, should we implement this gender ruling this coming election, or should we push it up to 2017, or when should
Yes.
we be able to implement it, and what have you? And that question is very much, strictly speaking, different in terms of the Finance Act and what you would be asking the Supreme Court. There was a legal
Yes.
basis within which that question was being asked to the Supreme Court, because the legal basis was Article 27 of the Constitution, Article 81, and Article 100 of the Constitution, which the Constitution itself speaks to this aspect of it being implemented. There's some particular facets, and there's some particular framework within which the Constitution has set, and it was just for the Supreme Court to give guidance of which things on how best this can be done, which is
Yeah.
different from the finance question of whatever nature you'd want to ask the Supreme Court
I,
in an
I ag-
advisory opinion, because
yes. I
there is
agree.
no, yeah,
I agree. But it was just kind of it was a hypothetical. I was just trying to bring out the issue of the advisory opinion being a tool of the Supreme Court kind of getting into the waters of policy, getting into
yeah,
the realm of the executive, getting into the
mm,
realm of the legislature. And as you were just talking about the gender advisory opinion, it also
yeah,
just came to also to fore to me something that you also had argued about. What is whatever the Supreme Court says on advisory opinion, what is its enforceability? What is its authority?
yeah. I think that is one of the biggest areas I've had the issue with the Supreme Court, because in the very first opportunity the Supreme Court had to pronounce on the legal effect of the advisory opinions, they
Yes,
said that the advisory opinions are binding in nature.
yes,
And they said that their legal opinions and advisory opinions are binding in nature because you'd be surprised the reason why what the Supreme Court gave,
yes,
saying that they cannot imagine
yeah.
anyone can come to them and waste their time asking them a question and them to answer that question, only for those people to go and ignore that question. That was reason
Yes,
number one.
yes,
Reason number two, the Supreme Court was giving was the nature of the proceedings are such
mm,
high stake, they
yes,
are as serious as any contentious proceedings,
yes,
and for that reason, there is no
yeah,
good reason, at least so far as the Supreme Court is concerned, why the
yeah.
advisory opinion should not be
Should not
binding. And
be
at this
banned.
point, they
Hmm.
distinguished themselves from the AG. They're saying you
Yeah,
cannot compare, my friend, our advisory opinion from the
and
advisory that you can get from the AG.
yes,
Ours is coming after a very rigorous process, and so it should be binding to anyone who asks that question. And for me, the question I was asking was
yes,
that, you know what, Supreme Court, those things that you're
mm,
saying are true. The
yes,
proceedings before you are serious, for sure, and they
mm,
involve complex questions. But guess
they
what?
do.
Every other court that exercises that jurisdiction, including the International Court of Justice, which is the world court,
Mm,
similarly is faced with perhaps even more complex questions, more
and more high
political
stakes.
questions, more high stake questions. But
Yes,
still, at the end of the day, its advisory opinions remains to be
mm,
advisory opinions, not legally
they're
binding. And
not
because,
legally binding.
and I have included this in my work, that there is only one way to attribute a binding effect on advisory opinion, and that is
Mm,
through the constitutive text. If
it's
Article
true.
165.6 itself was saying that an advisory opinion rendered by the Supreme Court is going to be binding, then we
Yes,
could not be having any question beyond that.
but as you said, let's just before we move forward on that issue, he's saying high stake
Mm,
proceedings like contentious matters, but in advisory opinions, the issue is kind of in reality it's kind of remote. It's
It's
might
an
be there.
hypothetical situation for sure.
It's an hypothetical situation. So
Yeah,
how do you compare it with a situation that is actually contentious? I think that is also
exactly.
a place where is it say like this dissonance? How does that how do you compare this with two people who are actually at loggerheads, while this
Yeah,
one party has just come to you to ask for an advisory opinion over something that they foresee, or some issue which is not yet
there
become
is suspense
live
out of the
into the
blues.
court. Yes. So I think that one, as you say, there's something there's some kind of there's murky waters. There's some, like, what should we say, like some lack of clarity on that issue. And as you're saying that it's not other courts have made it not binding. Well, our court has said it's binding. It's kind of enforceable. I don't know what is the measure.
For
How
no
do
good
we
legal
enforce
reason.
this?
It can't actually be enforceable. And I was saying,
Yes,
actually, if you look at one of my concluding remarks in my article is that one
yes,
of the dangers of the Supreme Court pronouncing its advisory opinions as binding is that
yeah,
it risks a form of embarrassment to itself
mm,
when what it is saying to be binding is not respected and it
yes.
lacks any form of mechanism to enforce it.
Yes, because
On the one
okay,
hand,
just
like,
let me just ask you. Let me just put it like to make it clearer. Like,
yeah,
you cannot extract a decree on an advisory
exactly,
opinion. Just continue.
exactly, exactly.
The issue of the its binding nature now. It's out of the water. So what is your comment on this kind of? I've had many quotes also describing this issue of the Supreme Court being like a jurisdictional monster. It's trying
Yeah,
to it's spreading into its tentacles to areas where unprecedented new areas, trying to get into more jurisdiction, abrogate jurisdiction to itself. Is this a false claim or a true claim? Especially in
it's
regard
for
to
me, it's a true
advisory
claim.
opinions.
And for me, it's a
Yes,
true claim, especially in so far as its jurisdiction of the advisory opinion is concerned.
yes,
The other day, I was having a conversation with my friend Joshua, and
yes,
it turns out that actually this aspect of the Supreme Court insisting that an advisory opinion has to touch on has only to touch on matters on affecting county government
yes,
is a creation of the Supreme Court. It's not something that is in the Constitution. If you read
yes,
the text of Article 165(6), it
yes,
seems to appear that it is only
mm,
county governments that are limited to ask questions that affect
yes,
county governments. And it actually makes absolute sense to say that
yes,
county governments cannot seek advisory opinion on matters that do not affect county governments.
true.
Such that you see that the Supreme Court from the word go, it's set in the rule IECC. And the question that was being
Mm,
asked there was, of course, when should the first national election be held under the 2010 Constitution? That is
yes,
where we got it wrong, and that is where the Supreme Court carried to itself jurisdiction of which it was warning. In that same judgment, the Supreme Court
mm,
warns about judicial innovation and judicial craft to
yes.
provide jurisdiction that is not provided for under the Constitution. And there are at least two principles that make the findings of the Supreme Court untenable. They are saying that if there is a contentious matter, and this is the distinction that we are trying to make here between an
Yes,
hypothetical situation and a live matter. Can you imagine the
yes,
Supreme Court saying that if there is a live matter that is pending in the High Court
yes,
and someone brings a question, an hypothetical question at the Supreme Court, the Supreme
exactly.
Court was saying that if there is public interest and there is and there is intense public interest why we should answer that question, then we are going to answer that question, which is very problematic.
Because
That
whatever it renders, it will affect
yes,
the ultimate decision of the High Court. And so,
exactly.
whichever way the High Court would have ruled, it will now be
Yes,
affected. It would not
And
be.
problematic bit is that the Supreme Court will be taking itself on a wild goose chase, as it would call
Yeah,
it in the sense that advisory opinions and advisory proceedings are hypothetical. They involve hypothetical situations in
and they
that
do not
nature
even
and what
involve
have
the
you.
taking of evidence, which is in those other
Exactly.
lower courts.
And the High Court proceedings will be a contentious
Yes,
dispute involving a live dispute. To
true.
imagine that an advisory proceedings can replace or can take over or can subsume a contentious proceeding is something that, in my view, is very problematic. But even the problematic bit of this is that the Supreme Court itself, setting these principles, has always applied these two principles of saying whether to refuse to issue an advisory opinion. So one wonders, why did you put it in the first place as a principle of whether you're going to take? Because you are damned if you apply that principle to accept jurisdiction. But then
Yes,
again, you look someone who is almost confused to have a principle that you always use to say that you cannot apply
mm,
it's basically saying it's setting a negative principle
yes,
that you don't have to consider in the first place, because it should not be a consideration in the first place for the Supreme Court to do something like that, to consider matters that are pending before the High Court, because
before
those
the High
matters
Court.
should reach to it
Their
through the
yeah
appellate procedures, if
process.
at all. And of course,
Yeah,
it is not every other matter. And I think this is another aspect some of the other senior advocates have been castigating the Supreme Court. These two limbs of general public importance and as a matter of right
yes,
are very narrow, but you can see how the Supreme Court has been navigating the waters and trying to introduce matters that should not necessarily fall. But even worse is that the Supreme Court has gone beyond even
yes.
going these two principles, at least in the Sonko case, where they are saying, as the apex court, we think that there are instances where even if we
Where
don't have jurisdiction,
we can take
it
up a matter
behoves us.
in our dignity.
It is our obligation, guys. It is why we are here.
It's our reason for existence.
It's our reason for existence, so that we can provide clarity to the nation. I mean, if we don't provide clarity to the nation, who will, if not
As
us?
uh,
Which is
as you have
problematic.
said, in that case of the IEBC case, they said we people do
Mm.
not come here to waste time. So whatever we do
Yes,
or whatever we say must be
yes,
binding, will be
yes.
enforceable in one way or another. Even if it's some kind of utopia, it will be. We will find a way. Some way will be devised for it to be enforceable one day. So, but anyway, thank you so much. Kenson, I'm sorry to cut you off, but I know you also have to rush somewhere else and do other
Yes,
things. So, but
yes,
we have really enjoyed this conversation, and we're
absolutely.
looking forward to doing more and more of this. And thank you so much. You can also bid goodbye to our listeners.
Thank you so much for inviting me. I think time has really
Zoomed.
I think it's the conversation that we're having were very interesting conversations,
Yeah.
and I hope that the audience will enjoy the conversation that we have had,
Yes.
and definitely look forward to having even more intense and more informative conversation
I've
uh,
actually, yes, I've
in
actually learned
future.
it so much more.
Yeah,
Thank you so much, and let's see each other next time. Bye to
that was our.
all
Thank you
our
so much.
listeners.
And thank you to your listeners, because without
Uh,
them, we could not be having this platform.
true, 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 true. See you next
Yeah.
time. Till next time.
Bye bye.
Bye.